have some sort of bond discussions. Everyone has waived preliminary hearings at this stage. As we've you may be aware, preliminary hearing obviously is just the stage where the complaints need to be bound over to the indictment process. We'll all waive that hearing today. As far as it goes regarding the bond, there has been a bond motion filed, there may be subsequent bond motions filed by the council as well. It's unclear this summer we're going to have an oral hearing on bond that may be handled just simply through either memorandum or affidavits, non-orally. As you may be aware, procedurally speaking, once someone files a bond motion, the prosecutor has a certain amount of time, typically at least 7 days, to file a response, and the court has an opportunity to make a decision in a reasonable amount of time after that. And it's unclear whether or not the grand jury proceedings will happen by that time. Grand jury proceedings at this time are scheduled, at least in some respect, towards the middle to the end of this month. However, it's again the prosecutor's discretion as to what is brought before the grand jury. So at this point, as defense counsel, we kind of want to stand there.
I think it's important to understand too that while attorney Dorian Baum and I are out here discussing matters together, and we did have an opportunity for 3 of the attorneys to meet with the prosecutor and kind of go over some preliminary matters here. These matters are all separate and distinct. So while each of our clients have separately and independently, after consulting with counsel, waived the preliminary hearing, we could see some separation here in these cases. There's obviously 3 distinct attorneys who are here today. There are 4 distinct attorneys who are working these cases. And as Attorney Baum mentioned, on the preliminary basis, the only thing that we are looking at is probable cause. And ultimately, that is something that is going to be presented to the grand jury, and the grand jury also has a standard of probable cause. So, from a procedural standpoint, we are still very early. None of the attorneys have discovery at this point, but we have discussed some of the material facts with the prosecutor, and we're not going to get into those here today. Yes, sir.
Yeah, can you say why you decided to waive preliminary hearing?
A preliminary hearing is largely a procedural matter. Probable cause standard is fairly low, and to be perfectly blunt, because we don't have discovery yet, and because we're at such an early stage, it doesn't really seem necessary to go forward with this part of the process. To be also perfectly frank, it's entirely possible that continuing negotiations and discussions will be had with the prosecution, which might make this whole part of the process moot. So it's not unusual. In fact, it's very rare that preliminary hearings do go forward.
Can you say it's what your name is, please?
I can tell you after we get off the record, yes. Yes, ma'am.
I know that yesterday or last week when we spoke, you hadn't gotten to speak to your clients yet. You guys have gotten to speak to your clients at this point or not?
So I believe Mr. Stolly has. He can talk more about that. Unfortunately, due again, in no small part, thanks to the travel of where the defendant has been en route, etc. There's miscommunication about whether it's going to be brought today, whether it was going to be hearing today, whether his presence was necessary here today. So unfortunately, I have been unable to meet with him, but my plan is to do so shortly hereafter.
And
Can you tell me a little bit about you certifying a lesser bond for Mr. Sarge?
About me wanting bond reduced?
Yes.
Yeah, I mean, obviously, in nearly any case where your defendant or your client is being held in jail, you want it reduced. At this point, I've already made quite clear that I have concerns about Mr. Sider's competence, whether he is suffering from mental health issues, from diminished capacity, etc. So, to be perfectly blunt, if a person like that is sitting in jail, that is a bit of an affront to me. I don't think he belongs in jail. I think right now he belongs out of jail, so we can address those medical issues and whatever mental health issues he's dealing with. And to be perfectly blunt, if he is not competent, he is not going to be easily prosecuted, if at all able to be prosecuted, in which case he's now just sitting in jail as somebody who's incompetent. So I frankly think that's an appropriate place for him. But again, that's a determination for the court. The court will make an appropriate decision, I'm sure, and we'll move forward.
You mentioned you have spoken to Elizabeth. What kinds of things have you talked to her about so far, and what have you been able to talk to her about?
I've spoken with Elizabeth, and I detailed some of that to a few different media outlets. At this point, what we discussed specifically was the nature of the preliminary hearing, what that is, because most people don't understand what a preliminary hearing is, how it differs from something like grand jury. We discussed some of her personal background and information that I know the prosecutor's office is trying to gather right now by way of their discussion, but we were able to get a baseline. I don't want to get too far into that. In regards to our bond motion, I do want to make a point here that it is my understanding, and I believe it is the prosecutor's understanding as well, that Elizabeth Siders has no criminal history. So when the court is looking at deciding what a bond is going to be set at, there are factors that are enumerated out for the court for them to help them make that decision. Ultimately, in this case, there's a lot of attention given the fact that you are all here, and it puts a lot of pressure on the court system. It puts a lot of pressure on the media as well. For my client specifically, not having any criminal history, to my knowledge, not having ever been charged with failure to appear, starts to mitigate some of those factors. Some of the things that courts will look at in a case like this is what does that criminal history look like? Have they ever been charged with failure to appear? Because we're trying to determine, is this person a flight risk? At this point in time, we are still not sure, at least at my office, whether my client is a victim herself or not. I have previously stated that she does not necessarily characterize herself as a victim, but the investigation from the prosecutor's office, the investigation from my office is still ongoing. So, with all of that and taking all of that into consideration, we anticipate filing a motion to modify Elizabeth's bond.
Is she the mother of all 16 children?
That is my understanding, yes.
What is her mindset right now? I mean, what is she going through in your conversations with her?
I have not spoken to Elizabeth today. I intend to later on today after this hearing. But at this point, as I had stated before on the record with several outlets, she was pretty distraught when I talked to her. I think still in shock.
Unfortunately, I do have to get going. Thank you, everyone. Appreciate it.
Thank you
Thank
so
you.
much.
Can you
Yep,
state
I-
your
I-
name
I
really
have
quick
two
and spell your name and state your name?
I can once we go off record, yeah.
Okay.
You filed several motions in court view that I've looked at least, including for a jury trial. Can you speak more about that motion? And
Correct. So my office filed what we call our initial pleadings this morning. I could talk a little bit about what those are. So first initial pleading is a basic motion for discovery. That puts the prosecutor's office on notice that my office is requesting any and all evidence that they have. Constitutionally speaking, they have to turn that evidence over to us. If for some reason they didn't turn something over, that could be what's called a Brady violation. The second thing that I filed was a defendant's disclosure of evidence. Now, at this point, that was a pretty bare bones document because we don't know what evidence the state has. I have not had an in-depth, detailed conversation with my client with regards to any sort of evidence that may need to be disclosed. Third document was a motion for a bill of particulars. That gives us more information than the indictment would. So specifically dates, times, how is the prosecution getting to this stage. Again, right now we are only on a complaint, criminal complaint. So these individuals, including my client, have not been indicted. But the bill of particulars will give us more information so we know how to appropriately defend our clients. And the final thing, as you mentioned, was the jury demand. So I file a jury demand as a matter of course in any case where the right to a jury trial attaches. It protects my client's right to a jury trial, and in many instances, a jury demand is required in order to preserve that right. Otherwise, it would revert to a standard bench trial.
Thank you for doing that.
Okay.
Thank you.
Do you
Yes.
know when this is supposed to go before the grand jury? Have you guys talked about that, or is it going to be a while still?
I don't know the specifics on, as Attorney Baum mentioned, grand jury is not something that defense has any part in. It really comes down to the prosecutor's office and when they are intending to schedule it. I believe the prosecutor's office is looking to do that soon.
What would you say is next, just for clarification purposes? We're waiting for the grand jury indictment. What's like the next step?
So from the prosecutor's standpoint, I think it's the grand jury. From at least my standpoint with my client, it is the continued investigation and trying to get a bond motion filed with the court as soon as possible. And we'll see if we're actually having an oral hearing on that. It may be better to just address it by motion. So certainly addressing bond in some fashion.
Thank you.